On October 17th, 2025, the Seoul Western District Court officially upheld the Ministry of Employment and Labor's decision recognizing Min Hee-jin's conduct as workplace harassment under Korean labor law. And this ruling strengthens the claims of former ADOR employee Ms. Kwon, but also it carries pretty serious implications for Min Hee-jin's ongoing legal dispute with HYBE over the put option case. So in this video, we're going to break down what the court actually said, why this matters, how it affects Min Hee-jin's legal strategy, and what it could mean for HYBE and NewJeans. And we will begin with the full timeline that led up to this decision. And yeah, we'll also talk about how the narrative around this case has shifted and what comes next as a civil lawsuit continues. Okay, so for more than a year, the dispute between Min Hee-jin and a former employee of ADOR, identified in court documents as Kwon, Ms. Kwon, that's how we know her legal name. It had played out in the shadows of mediation breakdowns, postponed hearings, and carefully crafted legal statements. We have talked about this on our channel, right? But with this decision, the court has, for the first time, drawn a clear legal line. That is, Min Hee-jin's conduct was not just harsh or controversial. It met the legal definition of workplace harassment under Korean labor law. Now, the roots of this legal battle stretch back to early 2024. So, Kwon, she was by then an employee of ADOR. She filed an internal ethics complaint to HYBE, alleging daily verbal abuse and sexually inappropriate remarks by a deputy director of ADOR at the time. And she claimed that the behavior was ongoing and well known internally, but it was ignored. And HYBE's investigation concluded that the deputy director's remarks were inappropriate, but stated that there was not enough evidence to categorize them definitively as sexual harassment. Again, that investigation took place while Min Hee-jin was a CEO of ADOR. But even so, HR department recommended a formal warning. But Min Hee-jin, who was then CEO of ADOR, refused to approve the disciplinary action and reportedly defended the accused, describing the complaint as a retaliatory act from a departing employee. She knew that the employee was going to leave the company. Now, in interviews later that summer, Ms. Kwon described that moment as the breaking point. So she recalled the company's handling of her report as deeply biased from the very beginning, saying HYBE did conduct an investigation, but Min Hee-jin continued to exert influence over the process. 다만 영향력을 계속 행사하셨어요. And she said, I didn't think the investigation was fair at all. She said she had filed the report because the harassment was happening all the time, every single day. 정말 매일매일 일어났던 괴롭힘이 있었어요. And she wanted to make sure that no one else would experience the same thing. But what followed left her feeling isolated, unprotected, and humiliated. And interestingly, she said that when she filed the complaint, everyone was supporting her within the company, according to her interviews. Now, the story became public on August 13th, 2024, when Ms. Kwon appeared in an exclusive interview with JTBC. Although she also, wrote, made her statements available online through her Instagram account that she created just for this purpose. Now, during the JTBC interview, she described the harassment in detail and accused Min Hee-jin of shielding the perpetrator, the deputy director, or vice president. And she said, the harassment I went through was handled in a completely biased way. And the way it was handled caused even more harm to me. Now, just days later, Min Hee-jin published a long rebuttal, 18 pages worth, on her social media, Instagram, denying all accusations and framing Ms. Kwon's actions as a retaliatory complaint. And that post, again, changed everything. Why? Because the Miss Kwon said everyone around me knew I was the person being talked about, even though she tried to remain anonymous, right? The Instagram account that she created was supposed to be anonymous. But she said, reading Min Hee-jin's statements made me feel like I was being portrayed as some crazy woman who couldn't do her job and filed a false retaliatory report. She said, everyone around me knew I was a person being talked about. She said that her identity spread quickly throughout the industry and she became the target of malicious comments and professional backlash. And we will briefly talk about, I have right here, when JTBC made that video available, you can still read comments that could be identified as, in Korean we say 2차 가해, the secondary victimization. All these commenters attacking the victim, which is, we'll talk about later. Now, in September 2024, Ms. Kwon escalated the matter legally. So she filed both criminal and civil complaints against Min Hee-jin and the deputy director involved in the case, and she submitted a formal petition to the Ministry of Employment and Labor. Now, around this time, shortly after Min Hee-jin's dismissal from her post as CEO, ADOR's new leadership announced an external reinvestigation of the incident. Ms. Kwon said later, I felt powerless when I found out Min Hee-jin had intervened in the process in a biased way. Now that a reinvestigation is happening, I just hope it's finally fair. By the end of 2024, the civil lawsuit was sent to mediation by the Seoul Western District Court. Kwon expressed willingness to settle if Min Hee-jin would simply acknowledge wrongdoing and apologize. But guess what Min Hee-jin did? Guess how she responded? You guessed it right. Min Hee-jin refused, and the case moved into full litigation. The pace picked up in March 2025. The Ministry of Employment and Labor issued its own ruling, concluding that Min Hee-jin's verbal conduct met the legal definition of workplace harassment and that she had failed to conduct an objective internal investigation. And a fine was imposed, a financial penalty, which was a rare outcome in Korea, and we have talked about this too, because fewer than 2% of such complaints lead to penalties, financial penalties. And that same month, the first civil hearing was held between Kwon and Min Hee-jin. Ms. Kwon's lawyers submitted a 2-hour audio recording related to the harassment. Although in this article it says visual recording, I'm not sure. So it's 2-hour recording related to the harassment. And the court ordered both sides to transcribe it. In April of 2005, Min Hee-jin filed a formal objection to the administrative fine, the penalty. In May this year, during the second hearing, Min Hee-jin's legal team challenged the evidence and denied all allegations, but the court made it clear it would examine the facts rather than dismiss the case early. During the summer, both sides continued to exchange briefs and evidence submissions, while Min Hee-jin's legal team repeatedly sought to delay the hearings. Now, it's super interesting how Min Hee-jin had like 7 lawyers with her for this case as well, from Sejong, whereas Ms. Kwon only had 1 lawyer to represent her. And in August, Min Hee-jin's lawyers filed their first postponement request for the third hearing. And on September 25th, they filed another delay request, and the court granted it. October 13th was set as a provisional hearing date, but the court noted that the schedule depended on the outcome of Min Hee-jin's challenge to the harassment fine. 추정기일, 추정사유, 관련 사건 결과 도착을 기다리기 위하여. And the decision came on October 17th, 2025, which was the news that I began this video with. Again, the Seoul Western District Court upheld the ministry's findings, ruling that Min Hee-jin's conduct met the legal definition of workplace harassment under Article 76 of the Labor Standards Act in Korea. Now, part of the fine was reduced, interestingly, but the substance of the ruling remained intact. And Min Hee-jin's legal team immediately announced plans to file a formal objection, yet again, which would move the case into a full trial phase. But I think the significance of the ruling was already clear. Now, let me briefly translate you and read you this article that came out on October 17th. Min Hee-jin committed workplace harassment. Court upholds administrative fine. The court has upheld the administrative fine imposed on former ADOR CEO Min Hee-jin over allegations of workplace harassment. On October 16th, Judge Chung Chul-min of the Seoul Western District Court Civil Division 61 conducted a summary trial and ruled to uphold the fine issued by the Seoul Regional Employment and Labor Office against Min Hee-jin. In response, Min Hee-jin's legal team announced plans to formally object to the court's decision. In August of last year, a former ADOR employee identified as A filed a complaint with labor authorities claiming she had suffered emotional distress due to Min Hee-jin's verbal abuse. She also alleged that she was harassed at work by B, an ADOR executive known to be close to Min Hee-jin, and that when she reported the harassment, Min Hee-jin shielded that person, the accused, and attempted to cover up the incident. In March, the Seoul Western branch of the Ministry of Employment and Labor concluded that some of Min Hee-jin's remarks constituted workplace harassment, causing physical and psychological distress and worsening the employee's work environment. The agency also found that Min Hee-jin, as an employer, failed to conduct an objective investigation after the report and imposed an administrative fine on her. Under Article 76 of Korea's Labor Standards Act, employers who receive or become aware of a workplace harassment report must immediately conduct an objective investigation. If the employer is found to have committed harassment, a fine of up to 10 million Korean won may be imposed. And failure to conduct a prompt investigation can result in an additional fine of up to 5 million Korean won. Min Hee-jin has denied the allegations and filed an objection to the fine in April. Speaking with this outlet, Min Hee-jin's legal team said they believe there were errors in the court's decision and plan to file a formal objection. The court reduced part of the fine, acknowledging some errors in the ministry's decision, which means we partially won, they said. Let me read that one more time. 법원은 고용노동청의 과태료 처분이 일부 잘못됐다고 판단해 과태료를 감액했으며 사실상 일부 승소한 것이라고 임명했다. So the Sejong lawyers said to this media agency who reported the case that the court reduced part of the fine, acknowledging some errors in the ministry's decision, which means we partially won. Wow. The article says, if Min Hee-jin proceeds with the objection, the summary ruling will be nullified and the case will move into a full trial. Now, what do you think? I mean, even though Sejong lawyers said what they said or said what Min Hee-jin want them to say, I think this has enormous implications. Why? Because until now, Min Hee-jin's legal strategy had hinged on buying time, framing the administrative decision as subjective or flawed, and maintaining, a narrative, public narrative, that the case remained unsettled. But that is no longer possible. I mean, the court has spoken clearly, and the decision carries far more legal weight than the original ministry ruling. Like, even if Min Hee-jin proceeds with her stated plan to file an objection, the legal landscape has shifted even more dramatically, compared to the past. And the starting point is now a court ruling recognizing workplace harassment, not an open question. And if you think about it, this ruling also reverberates through Min Hee-jin's other legal battles, like in the civil lawsuit with Ms. Kwon, where she faces claims of defamation and damages. This decision can and almost certainly will be used by Ms. Kwon's legal team, lawyer, to strengthen their arguments. And a civil court may take into account that a separate court has already found harassment occurred when assessing liability and damages. And even more strategically, if you think about it, this ruling intersects with Min Hee-jin's high-stakes legal battle with HYBE over the put option contracts. Like, HYBE, I think, can now point to a formal judicial finding that Min Hee-jin failed to meet the standards of a responsible corporate leader. And that is reputational damage, but plus, it can shape the legal and financial arguments in their ongoing corporate disputes, whether Min Hee-jin wants or not. Now, for Min Hee-jin, again, whether she wants or not, this marks a pivotal moment, because over the past year, she has tried to control the pace and structure of the legal fight by repeatedly postponing hearings. She slowed down the civil case and bought time to manage multiple battles at once. But this October 17 ruling is outside her control, and its impact will ripple into every related case. The ruling itself came out on the 16th, but we heard about it on 17th. And again, legally, Min Hee-jin's team has already signaled that they will file an objection, which would send the case into a full trial, but an objection won't erase the court's reasoning. It will simply reopen the case with that reasoning already on the record. And that's already a different battlefield than the one Min Hee-jin has been fighting on so far. So what happens next will depend on how the court handles Min Hee-jin's continued delays in the civil case. The third hearing, which was scheduled for October 13th, but postponed after Min Hee-jin's September 25th filing, still needs to be rescheduled. And whether the judge grants further delays or pushes forward will show how much patience that the judiciary has for Min Hee-jin's strategy. But meanwhile, the harassment ruling will likely tighten the legal pressure around her, forcing her to fight on multiple fronts simultaneously. I wonder how she sleeps each night. Not that I care. Now, the next hearing has not yet been scheduled again. If you hear about it, we can talk about it, if there's anything significant worth talking about. But again, the October 13th date passed without a session, and the court will likely set a new date for late 2025 or early 2026. And if Min Hee-jin files an objection to the October 17 ruling or 16 ruling, the civil court may wait a bit to see how that process unfolds before moving forward. And this case also affects Min Hee-jin supporters. And I know some of them often come to my channel whenever I upload videos related to Min Hee-jin or NewJeans to express their support. And we know who you're talking about. And for over a year, one of the most persistent talking points from Min Hee-jin supporters, including some NewJeans fans, was the idea of her eventual return to ADOR. But a workplace harassment ruling fundamentally changes that conversation, because from a corporate governance standpoint, reinstating a CEO who has lost a harassment case would be virtually impossible. Although, I think regardless of the decision, it's impossible. But who knows? Maybe some other companies were trying to recruit her as a leader of their ventures, but good luck to them. And it can also affect the put option case, again, between Min Hee-jin and HYBE, because even though the harassment case and the put option dispute are technically separate legal proceedings, they are strategically and practically intertwined, right? Because The court officially recognized Min Hee-jin's conduct as workplace harassment under Korean labor law, and that finding can be used by HYBE to strengthen their position in the corporate lawsuit. And in the put option case, right, Min Hee-jin is essentially trying to argue that HYBE acted improperly and unfairly in its dealings with her as a shareholder and executive. And her credibility and leadership record were central to her legal and public standing. But now that a court has found that she engaged in workplace harassment and failed to conduct an objective investigation, HYBE can cite that ruling to undermine her claims. And yeah, this could give HYBE a much stronger legal and narrative position. And the company can argue that her removal as CEO was justified and that it had legitimate grounds to limit her influence in corporate decision making. And it also damages Min Hee-jin's ability to frame herself as a wrongs executive who was unfairly pushed out, although that's what her supporters have been saying again and again. And like I said, some entities out there might have mulled over the idea of recruiting Min Hee-jin someday, but this also has reputational consequence, right? Because in an industry that relies heavily on public perception, a CEO who has lost a workplace harassment case faces a significant loss of credibility, assuming that she has any credibility left. And it makes it more difficult for Min Hee-jin to build public support, or negotiate from a position of strength, or claim moral high ground in her battle with HYBE. And while the two cases involve different legal issues, courts are not blind to context, right? Judges in the put option case will be aware of this ruling. And even if it doesn't decide the outcome directly, it can influence how Min Hee-jin's claims are received and how much weight the court gives to her arguments, unless the judges are getting influence from her Min Hee-jin's what was the shaman? Yeah, unless they're spellbound or something. So, but overall, the harassment ruling, I think, is a serious blow to Min Hee-jin's overall legal strategy. And why? Because it weakens her credibility, strengthens HYBE's hand, and it limits her room to maneuver, and it could shift the balance of power in what has been, very conflicting and interesting legal battles. One of the most talked about and closely watched legal battles in the Korean entertainment industry. Now, do I have these? Oh, the comments. So I said when the JTBC first made that interview available on YouTube and through articles, there were lots of commenters, commenting to attack the former employee, Ms. Kwon. And it was a textbook case of secondary victimization, or what's commonly referred to in Korea as 2차 가해. Again, after Kwon went public on JTBC in August 2024. The legal process was still in its early stages. But before any ruling, before any official acknowledgement, supporters of Min Hee-jin flooded the comment sections and online spaces with attacks aimed not at the accused, but at the victim, Ms. Kwon. And it was a targeted backlash. They questioned why Kwon was demanding an apology from Min Hee-jin instead of the perpetrator, and they mocked her credibility, Ms. Kwon's credibility, and they even dragged her salary into the discussion as if it undermined her right to speak out. And that salary was revealed by not the victim herself, but by Min Hee-jin through her Instagram. And other people dismissed Ms. Kwon entirely, calling the news clickbait or accusing her of stirring unnecessary drama. And some people flat out implied that she was lying. You can still read these comments if you revisit the JTBC interview video. But as of October 17, 2025, everything about those comment sections reads differently, right? The court has officially ruled that Min Hee-jin's conduct constitutes workplace harassment under Korean labor law, and what many people once dismissed as baseless or exaggerated has been legally recognized. The people who said, go to the police, Ms. Kwon did. She did. The people who said, there's no evidence, there was, and the court agreed. And the people who said, why target Min Hee-jin? Well, now they have their answer. And yeah, these accusations that were once dismissed as baseless has been legally recognized as workplace harassment. And the claim that Ms. Kwon should just go to the authorities just ignores the fact that she did exactly that and won, even though she had only one lawyer and Min Hee-jin had like 6, 7, or 8. And the reality is that many of Min Hee-jin's supporters engaged in secondary victimization, whether intentionally or not, amplifying, her denial and silencing the victim's voice. And speaking of the victim's voice, let me end this video by reading you the statements that Ms. Kwon put out on her Instagram in the beginning. She did that in Korean, but here's an English version, okay? And then we'll wrap up the video with questions to ask to you guys. Here we go. I am the employee referred to as B, person B, in CEO Min Hee-jin's explanatory post on Instagram on July 31st, where I was called a crazy bitch and accused of suffering from mental illness. As Min Hee-jin mentioned in a conversation with Executive A on Kakao Talk, if that gets out, she will just end up ruining herself. Does B, referring to Kwon, have the guts for that? Yes, I'm simply an ordinary employee, a regular person without much courage. The idea of standing against a seasoned star producer and CEO with decades in the entertainment industry, adept at handling press, was unimaginable to me. Even as I write this, I am extremely fearful. However, given that Min Hee-jin has publicly disclosed employee conversations claiming to clarify her innocence without any consent or notice to me, and continues to insist that her insults weren't directed at me, that the Kakao Talk messages were manipulated, and with numerous other lies, I cannot stay silent any longer. Having left the company without support from any media outlets or the two companies involved, I hope to clarify the facts and resolve misunderstandings with this somewhat lengthy statement. I appreciate your consideration in reading this entire message. After leaving the company in April, both companies collided, and I was investigated based purely on being a former employee under Min Hee-jin and Executive A, the vice president of ADOR at the time. Media outlets contacted me about the issues I raised. Still, I declined interactions before now to avoid further complications from the ongoing legal disputes between Min Hee-jin and HYBE. When Dispatch released the article detailing the incidents, I was in shock. The article's hurtful language immediately led me to grasp context. Yet, I cross-checked the details multiple times to be sure before deciding to take this step. Before delving into specific matters, I would like to express how, soon after I reported Executive A, both that person and CEO Min Hee-jin began to intervene in the investigation process using insulting and degrading language against me. Despite such behavior, I thought they might harbor some small sense of regret for their actions. As someone who had once been an ardent fan of Min Hee-jin, spending significant amounts in the Weverse NewJeans shop, and contributing earnestly to the ADOR team, even post-resignation, seeing my efforts trampled and betrayed was disheartening. Though Min Hee-jin declared that no one should suffer from the distortion and manipulation of truth, ironically, she did exactly that by misconstruing and using private text sent after I left the company to her advantage. Number 1, my experience at ADOR. Let me first explain my experience at ADOR. During my time working directly under Executive A, I endured not only inappropriate sexual remarks, but also various forms of workplace bullying and unfair treatment, which led me to officially announce my intention to resign on March 2nd. Following this, I reported the incidents of sexual harassment and workplace bullying to the company on March 6th, received the results of the investigation on March 16th, and resigned on March 21st. I reported Executive A's unfair, I'll just say his name, Lee Sang-woo, unfair demands and harassing remarks as workplace bullying, backed by substantial evidence. Given Executive A's history of similar issues and his senior role within the industry, reporting him was intimidating. Nonetheless, I took the initial courageous step to address the threat within the organization, knowing I wasn't the only one affected by his behavior. Lee Sang-woo consistently criticized and harassed both me and my team, often issuing oppressive work orders via KakaoTalk outside of work hours, which gradually eroded my self-esteem and personal life. Those who have suffered baseless bullying in the workplace will understand this pain. He issued non-urgent work orders through KakaoTalk, even on weekends and holidays, contacting me early in the morning with painful admonishments. Sorry.
Admonishment.
Okay. Did you hear that? All right. Cool. In a 40-minute conversation that was not recorded in KakaoTalk, he made problematic misogynistic remarks such as having a young woman at the table makes the atmosphere better than two men dining together. Interesting comments. Once, when I responded within a minute to a Saturday work order from him, I was reprimanded, confused as to why I immediately answered his message given the few seconds between his text and a group message from CEO Min Hee-jin. I found his reprimands and criticisms to be incomprehensible. Furthermore, during overtime, he unexpectedly summoned me, demanding, "Since we need to evaluate you, what's your ambition in staying with the company?" Faced with this unexpected question, I said I would prepare an answer, only to be berated under pressure for suggesting a prepared response. But only because I could not address my ambition right away, he said he has to rate me failed. When I attempted to leave work around 8:30 p.m., I was asked to start a meeting in 30 minutes. I suggested starting immediately or conducting it remotely later, only to be shouted at, demanding, "Can you explain the entire project right now? How can we have a meeting straight away?" Insisting on starting 30 minutes later, I had to organize the entire project for the meeting that night and worked late as a result. It wasn't the work itself that was difficult, but rather dealing with such emotionally charged confrontations that were taxing. I failed to see how this can be dismissed as a simple misunderstanding between Executive A and me. Unfortunately, HYBE concluded that there was insufficient evidence of sexual harassment, but workplace bullying was inappropriate. Including the inappropriate dinner meeting, it was clear that Executive A's behavior was inappropriate, so they recommended to CEO Min Hee-jin that stern warning measures be taken against him. I felt HYBE's response was overly lenient considering the suffering I endured, but I chose to let it go given my decision to leave the company. It has come to my attention recently that CEO Min Hee-jin actively defended Executive A from the day I reported the issue until after the investigation concluded. And we have evidence that she indeed did. The KakaoTalk messages and the message that she sent to HR management, defending him and telling them that is there any way that they can punish Ms. Kwon instead. She engaged in excessive insults, branding me with derogatory terms like crazy bitch and insane to invalidate my report, rather than verifying facts and addressing issues as a responsible leader should have. Her portrayal of me as an employee who left complaining without doing work or making only nuisances is disheartening for someone who dedicated themselves to the company. Despite the circumstances, I hoped my departure would improve the situation for my colleagues. Courageously sending messages to CEO Min Hee-jin detailing Executive A's incompetence and bullying in hundreds of lines on March 21st. From Thursday, the day I resigned, until Saturday morning, I sincerely thought about the organization as I sent those messages. I understand the intent behind urging me to meet with Executive A post-resignation as an effort to mediate and encourage further cooperation. Yet, simply letting time pass without an apology does not erase past misdeeds. Number 2, details regarding the incident. I would like to provide a more detailed explanation regarding this incident. It may be shocking, but the insults mentioned in the dispatch article were indeed directed at me during work. In Min Hee-jin's official statement, my report was misrepresented, and the context from March 6th to March 16th was cleverly edited, with certain details masked as work-related even though they weren't, mixing small lies to obscure the truth. Min Hee-jin's claim that her statements and materials are truthful and devoid of distortion or misconduct ironically contrast with her editing and public disclosure of my private messages, manipulating the overall context. It's profoundly shocking and hurtful to see someone who should understand my torment best using it in dishonest explanations. I'm disheartened by Min Hee-jin's insincere claims of neutrality and optimal mediation in her statements, especially since she pushed me to such extremes during my time at the company. In particular, ADOR had a break on February 15th, yet she claimed otherwise. She also fabricated principles like non-disclosure to the complainant, even though the report was immediately shared with her, allowing direct contact with me. The mixture of petty lies woven into her lengthy explanation is astonishing. The point that drove me to speak out despite staying silent was a sheer disappointment in Min Hee-jin resorting to the very manipulation and distortion she criticized, releasing my messages without consent. The claims that the dispatch article's insults were directed at someone else or that she twisted the context of my resignation for the public are disheartening. It's unfair for her to deny wrongdoing towards someone she once worked with and to have not expressed any remorse or apology. Everyone makes mistakes, and it is only right to acknowledge and apologize for them swiftly. Number 3, on Min Hee-jin's explanation. It seems likely that CEO Min Hee-jin might claim that the KakaoTalk conversation between Executive A and herself were merely casual chats and that their disclosure is a real issue. To this, I would like to ask her. Without a word to me, CEO Min Hee-jin published those KakaoTalk messages in her explanation, spreading distortions publicly. Even now, over a week later, there has been no apology or understanding extended to me from Min Hee-jin. Given the reasonable suspicion that intervention during the investigation stage may have influenced the outcome, for me, this matter is not something that occurred privately between the CEO and Executive A, but rather a professional, work-related issue. At ADOR, most work reports are conducted via KakaoTalk, so I view KakaoTalk conversations regarding company matters between the CEO and executives as effectively equivalent to communications via official work messengers or emails. Interesting because within HYBE, we have heard that they use Slack, which is a communications app and software that a lot of startups nowadays use. But for some reason, ADOR people, when Min Hee-jin was the CEO, used KakaoTalk, used KakaoTalk for work purpose. Let's continue on. Regarding the events between March 6th and 16th, can you truly claim, Min Hee-jin, that you acted naturally and fairly as a company representative? Instead, Min Hee-jin shared the report details she received as CEO with the accused, Executive A, in real time, suggesting and reviewing his objections, clearly taking sides with Executive A. And there's evidence for that as well, right? There's doubt whether a proper investigation was ever possible, given the environment where the report was buried and the complainant was insulted from the start by both the CEO and the executive. And by, executive, she's talking about the perpetrator. In cases of sexual harassment or workplace bullying, it is basic common sense to separate the complainant and the accused. Yet, requests were made to create an oppressive environment with Min Hee-jin, Executive A, and me in a three-way meeting, or even adding HR or client for a four-way meeting, pressuring the complainant. At the time, I was stressed by the tense atmosphere whenever left in the room with Executive A and officially requested a separated environment. Hearing such statements during such circumstances left me devastated. Although I try to understand, the current situation remains unfathomable. CEO Min Hee-jin trampled and insulted me with terms like crazy bitch, psycho, insane, and deserving 인신의족, which means like life is a reality. It's a derogatory term. While encouraging Executive A to hire a lawyer to press a false accusation lawsuit, employing her power to invalidate my report through various means. Therefore, I must again ask if Min Hee-jin's statements in her explanation about taking a neutral stance as a company representative and acting appropriately as a mediator truly reflect her actions. In Min Hee-jin's narrative, I was cast as someone deserving of such insults, viewed not as a victim of Executive A's actions, but as an incompetent leaving to ruin others, a being deserving of divine retribution. Yet, I was merely a member of, divine retribution is, the language that Min Hee-jin used in her KakaoTalk, I think. Yet, I was merely a member of ADOR, performing her duties diligently, aiming to be an asset to the organization. I am awaiting a sincere apology from CEO Min Hee-jin and Executive A. I hope not to witness another instance of missing the point as happened before. Please correct the known inaccuracies specifically. If you claim that even my statement is edited and false, I will take additional action to clearly reveal the truth. So that was first statement that we just read. And at the time, Min Hee-jin still had a chance. She could have entirely avoided this battle, if she simply apologized, even privately, but she never did. And she had to involve her lawyers to fight this former employee to prove that Min Hee-jin herself was innocent and this former employee was a manipulator. So she kept denying, which led her, Ms. Kwon, to release a second statement, which read, Second statement, August 19th. I am B, a former employee of ADOR, who is genuinely outraged by CEO Min Hee-jin's continuous false claims and damaging statements filled with new defamations, resulting in ongoing harm. So here we can see she's angry. And I could totally understand. I mean, I cannot imagine how much she must have felt, because she had to do all this alone. She's already outside HYBE. Man. All right, her statements that selectively address issues without mentioning her breach of neutrality as a CEO, her vile insults towards me, or her deceitful behavior are exactly as I anticipated. Attempts to bury the core issues and deflect the conversation. I urge you to clarify and apologize specifically for the 3 points I outlined at the end of my previous statement. I will critically address her attempts to deflect and the unfounded claims about my performance. Number 1, regarding the claim that the case was closed without charges and that she was not biased. CEO Min Hee-jin stated, upon receiving Ms. Kwon's contact after the investigation concluded, and as the resignation was taking place, I felt a chill but wanted to hear her side. Since the case was concluded, there was no necessity from my perspective to do so. CEO Min Hee-jin. So she still used that terminology, 대표님, representative or CEO, in her statement in a respectful tone, although her language overall was filled with frustration and anger. CEO Min Hee-jin, what do you mean by there was no necessity? It is within your duty and responsibility as a CEO of ADOR, where I worked, to investigate it and process incidents of internal bullying and sexual harassment. You could delegate the investigation process to HYBE HR, but you, as a CEO, are legally and procedurally the final decision maker for disciplinary actions regarding ADOR employees. Thus, neutrality and mediation as a CEO is a legal obligation from the beginning, exactly what you are paid a high salary to do. Furthermore, please explain your efforts to have Executive A acquitted and your refusal to even issue a warning despite being the final decision maker in this matter. Why do you keep pretending ignorance about your decision to shield Executive A from even a warning, claiming it was not within your remit? Based on labor law, I will legally respond to any inappropriate handling of workplace bullying reports. And she kept her word. She did, and she won. Number 2, regarding the claim of retaliatory false reports. Can you specify what falsehood occurs in my report? CEO Min Hee-jin, stop spreading falsehoods and deflecting the issue. I reported 7 instances of workplace bullying and 1 of sexual harassment, each backed with ample evidence. In particular, concerning the most contentious harassment report, Executive A already admitted wrong and apologized in KakaoTalk messages with you. There are no false claims within my report. HYBE intends to reinvestigate, and I have submitted 11 additional reports and evidence. I will also seek assistance from external agencies beyond HYBE. For clarity, I have attached my full report text as you seem confused about the details. Number 3, about public disclosure of salary and the 40% pay cut, quote-unquote, massive sale of salary. CEO Min Hee-jin, the high salary offered to person B, Ms. Kwon, was decided by me, a fellow woman. 40% reduction. Disclosing an employee's salary and arbitrarily cutting it by 40%, then publicly stating the reason without my consent are illegal acts. Min Hee-jin's response in her statement is unsurprising as it matches my expectations, but her actions of carelessly discussing and publicly disclosing my salary, subsequent unilateral reduction, and even the reasons behind such reductions are not only legally offensive, but astonishingly rude and arrogant. Throughout my career, I have always strived to give my best and have consistently received high evaluations in every place I have worked. 3 years ago, even without incentives, I earned more than at ADOR, receiving similar offers from other companies. Let me also address the pay cut. Arbitrarily reducing an employee's salary without following legal disciplinary procedures or prior notice is illegal. Even within the legal confines for a pay reduction post-disciplinary action, statutory limits exist. A nearly 50% salary reduction clearly signifies an attempt to coerce resignation. Number 4, assessment of job performance and probation completion. CEO Min Hee-jin said, due to these issues, the evaluation at the end of person B's probation was not favorable. There was a consensus among executives that continued employment would be difficult. 5 people participated in my 6-month probation evaluation, and except for Executive A, Lee Sang-woo, whom I worked with for only a month, all evaluation results were strongly recommended, meaning she got the top grade, or recommended. Executive A was the only one who gave not recommended, the worst evaluation possible. Why distort documented evidence? Moreover, CEO Min Hee-jin mostly worked from home, rarely coming into the office. Came to the office 3 times over 6 months to be specific. Despite being under her direct staff, I only saw her a few times, usually during brief meetings with external parties. How can a CEO, detached from the day-to-day dynamics of where employees work, unbiasedly evaluate each staff member's performance? Clearly, this is not possible. If I was truly incompetent, why do countless former colleagues empathize with my situation and offer support? Would ADOR's clients send messages of encouragement against Min Hee-jin, siding with someone allegedly incompetent out of mere revenge? Let me read that one more time. Would ADOR's clients send messages of encouragement against Min Hee-jin, siding with someone allegedly incompetent out of mere revenge? So meaning there are some, people, clients of ADOR, sending support messages to Miss Kwon because of what she had to go through. She continued, "You painted me as a team leader. And when was I? Oh, okay. So you painted me as a team leader, meaning in her statements, 18-page long statement. But when was I ever entrusted with such authority? I was a simple staff member without subordinates. I faced constant abusive reprimands, accused of inappropriate conduct for simply arranging lunch with key clients ADOR needed. The leader of ADOR's business team held another title and wasn't me. I find it laughable that your critiques of my skills culminate in citing typos and unfamiliarity with work. That supposedly justifies a 40% pay cut and enduring harassment. This reduction and the expectation that I accept such bullying with silence are absurd." The core issue is Min Hee-jin's concealment of workplace harassment, lies, public deception through manipulated context, and unauthorized KakaoTalk disclosures. Despite her verbose explanations, which deviate from the essence, I have responded to significant portions. Please stop with selective explanations and answer my questions. As a CEO, during the investigation of my workplace harassment and sexual harassment claims on March 15th, did you talk with the accused Executive A, insulting me with terms like psycho, insane person, or bitch, and support Executive A? Is such behavior a neutral stance deserving of a CEO while processing my harassment and bullying report? On July 31st, when you publicly disclosed my KakaoTalk messages to clarify suspicions about you, did you ever apologize or seek consent from me? Wow, she's so articulate. Man. Sorry that HYBE lost such a talent. Anyways, let's continue. My performance, salary amount, or Executive A's wrongdoings are not the main issues. If Executive A challenges my claims, does it instantly invalidate my reports as false without warranting investigation? Is it acceptable for the world to know me as an incompetent employee making false accusations out of revenge? All I sought was for falsehoods to be corrected and a public apology. I did not demand your resignation as CEO, surrender at a police station, or any money. However, you cannot offer a simple apology, which powerless employees resort to, hanging their heads in regret through countless apologies. Instead, as if flexing terms like low performance and citing salary reductions, indeed forcing it, how many employees would voluntarily accept a 40% salary cut? Now you have brought us to this juncture. We will meet at the court. Oh, this was what a ending. We will meet at the court and the Labor Department soon. I urge you, as confidently claimed, to pursue me for false accusations. If you know the meaning of shame, refrain from speaking publicly to audiences. Mic drop. Bam. Yeah, there's a reason why I decided to read these lengthy statements now that the court made an formal acknowledgement. And then this is the last slide. My questions from the first statement. Did you coach the perpetrator while hurling profanities at me behind my back? During the investigation, did you interfere by asserting that Executive A was innocent without maintaining neutrality? Why did you disclose our KakaoTalk conversations without my permission and distort various facts, including the reason for my resignation? Explanation by Min Hee-jin. Your salary of 130 million won is too high. I was planning to cut it by 40%. Her answer, this is illegal behavior and a boast. You didn't perform well at work, and she responded. Everyone except Executive A, who worked for only a month, rated me as highly recommended/recommended. Min Hee-jin said, you seem to have made a false report and it's scary. Kwon's response. The Executive A admitted his fault on his workplace bullying and also apologized right after the first statement, while you were pressing me with 77 KakaoTalk messages with no apologies. Min Hee-jin said, the investigation concluded with a no charge. I mediated. Her response, the CEO, responsible for handling workplace harassment, coached them to ruin the reporter's life and rejected even the strict warning suggested by HYBE for the perpetrator. And Min Hee-jin said, are you with HYBE? No, I am not. No, HYBE, meaning, are you working on behalf of HYBE? Attacking me? And she simply said, nope. Again, I don't know Ms. Kwon personally, so I cannot judge her, personalities as an individual. But man, she had to go through a lot, especially these witch hunts at the time conducted by Min Hee-jin supporters. So I hope she stayed mentally healthy throughout the process, and I hope she finishes strong. With whatever's remaining in terms of this legal battle with Min Hee-jin. All right, but I don't know. Maybe you guys think differently. So leave your thoughts. So here are my questions. How do you think this ruling will reshape the public perception of Min Hee-jin going forward? Yeah. And do you believe that this legal outcome will influence her ongoing corporate lawsuit against HYBE? Or will the two cases remain separate in the public's mind? And what about in legal, space? And in cases like this, where public opinion formed, long before the verdict, like this secondary victimization, 이차가해, how should platforms and communities handle, misinformation or, 이차가해, secondary victimization? How should we conduct conversations in a more appropriate manner? Okay, so here are some questions that I would like to leave you with. And as always, let's stay positive, respectful, and classy when we leave comments in the comment section. All right, see you guys later. Peace and love. Bye-bye.